Thank you. You may be seated. And recognize that board member Skicken is en route and will join the meeting in progress. So good morning to my fellow board members. Good morning. We'll dive right into our agenda. I move to approve the minutes for the July 25th, 2024 board meeting.
I'll second that motion. I do have one friendly amendment, if I could make on page 3 about the sublease, and I didn't get a chance to reach out to Mary beforehand. It's real minor. So it's about 3/4 of the way down. My board member David Chappelle stated, since there is a lease, perhaps it is important to have a lease. And then it says needed it's just a typo, needs to be executed. So just eliminate the phrase needs to be, and it would just say perhaps it is important to have a sublease executed. That's really yeah.
Strike those 3 words. Any other amendments? All right, thank you, Ms. Chappelle. Hearing none, all in favor of the motion, aye?
Aye.
Aye, the ayes have it. Thank you. And I move to acknowledge following Secretary of State directives, Directive 2024-16 and 2024-17.
I'll second that motion.
Seconded. Any further discussion?
Just one question.
Please.
So it looked like on Directive 2024-17, the report of the verification of signatures was due today. Did the Secretary say that we in a position to get that over or what?
Correct, it's due today at noon, and we will get there right at the finish line.
Okay.
So Asani, while he's up there, he's got his team plugging away. We had, there's one last one that we are finishing up. So majority of them are done. We'll get there.
Great. Thank you.
Motion before us, all in favor, aye?
Aye.
The ayes have it. Thank you. And we have an update on our security policy. The chair recognizes Mr. Peter James.
I'm just gonna prep before that the security policy, there's only so many things that could be said, or at least you're no longer secure.
And one quick question, and Peter may or may not know this. Will the items that we spoke to CISA and the Homeland Security, or during some of those things that came out in that conversation last week, will those be followed up on? They may not make it into the policy, but or maybe they will. I don't know.
I don't think, well, those are, they may or may not get into this policy, but they're gonna be action items that we will do for operational.
Okay.
So.
And there's nothing contrary, they fall into the current policy. I would
Yes,
say.
okay.
Yeah,
Yeah, no, there was nothing, material, but there was some good
right, it's
suggestions.
more how execution would be.
Yeah.
Correct.
Exactly, and that's something that we don't need, for approval, we can execute those, and we will.
Mr. James?
Good morning, Peter James, Election and Compliance Administrator. Nothing like starting off Monday morning and talking about policy. Directive 2024-10 requires all boards of elections to provide the Secretary of State's office with a copy of its most recent security policy, emphasis on the singular policy. I say this because this body approved several policies in January of 2020 that in one form or another touched on either physical or cybersecurity here at the agency. We reviewed these policies, freshened them up, quote unquote, a little bit to make sure that they properly reflected all directives and updates to the election officials manual that has taken place over the last 4 years. In addition, we pulled out a section of or a portion of the large security section in the election administration plan that was approved in June. And included that along with the policies that was adopted in January 2020, of which I bulleted on the 1-page summary sheet that you should have received. Put all those together and that becomes our one single security policy. Want to note that Directive 2024-10, the one we're talking about here, had a compliance checklist of which one item was a security policy. Directive 2024-09 had its own compliance checklist. That's the readiness one, which basically is a list of items sort of outside of this cybersecurity world that must be completed in time for the November election. I'd say right about this point, we're probably about 70% complete on all the items in the compliance checklist for Directive 2024-09 and 2024-10. And we're well on our way to being 100% compliant with these items by election day. Okay, that's it. If anybody has any questions?
Any questions? All right, thank you, Mr. James. I move to approve the Concord County Board of Elections security policy.
A second.
Second by Ms. Chappelle, all in favor, aye?
Aye.
The ayes have it, thank you. And on to item 4. Move to acknowledge the following resignation and appointment: the resignation of Tracy Mitchell, Jonesville Heights Board of Education Board Member, and the appointment to elected office of Keith Fuller, Jonesville Heights Board of Education Board Member.
A second.
Second by Ms. Chappelle, all in favor, aye?
Aye.
The ayes have it. Thank you. And then we have withdrawal, Mr. Lawler.
Law Manager of Canada Division Services. Good morning.
Morning.
You received in your packet over the weekend, 2 withdrawals, one from Maple Heights 5A local option from the city schools. We had 2 withdrawals this morning. We're starting to do good 1D on the VMPR, so you should have an updated sheet. Apparently there's 4 issues being withdrawn from that.
Thank you, sir. Any questions for Mr. Lawler? Sorry, can I acknowledge the acknowledgement of the issues withdrawn from the November 5th, 2024 presidential general election?
Second.
Second by Ms. Chappelle, all in favor, aye?
Aye.
The ayes have it. And then on to item 6, Mr. Lawler.
So Division of Canada,
Yes,
that's good to go.
okay. All right, any questions for Mr. Lawler on the certification? I've listed before us. All right, all in favor, I move to certify the candidates for the November 5th, 2024 presidential general election.
A second.
Second by Ms. Chappelle, all in favor, aye?
Aye.
The ayes have it. And I think item 7, we have several things, Mr. Lawler, getting one.
With the divisions.
Yeah.
Oh, it's fine.
Again, in your package, you would have for the subject, but we can ignore that.
Yes, we will know
There's 2 remaining local option petitions. One is the first one will be Bay Village 1B, Holiday Restaurants. The owner Queen is here, and you can speak with him. We reviewed the petition, there were 2 signatures short. He did go out over the last week and got 2 sworn affidavits, which you have in your packet. And he's requesting that, and you also have a chart that registration manager Sunny Wheat prepared for us. It shows the signatures on the petition versus the signatures in the registration database. And if you look at the 2 affidavits, the signatures in the affidavits do match what's in our registration database. So Quinn's asking that the board acknowledge those 2, accept them, and that would make it valid, and we would certify it to the board.
Okay, thank you, sir.
Yeah, I just, I don't know if we're gonna have a hearing or testimony on this. I mean, it just seemed to me the affidavits, would have been even more persuasive to me if it actually said, if the applicant said, I signed it. Doesn't say that, but I do agree that their printed names on the affidavit seem to match what's on the petition, so I don't have any, I mean, one was kind of faint, but based on my squinting, it looked like they certainly were the same folks. So just whoever drafted the affidavit just would have been even more persuasive to me if the applicant just actually said, that is my signature and I did sign, but it's fine from my perspective.
We'll remind people in the future, we don't trap them, we will remind them.
Yeah,
So,
I know that. Just to
yeah.
be with the unit.
Putting it
That's
out
all
That's
there.
a good point. I mean,
Yeah, I
something
mean-
we can remind them to. be
That's the
sure.
most persuasive evidence is the testimony that the person, I did sign that petition and that is my signature. But, that's, I'm good with it.
Intended to sign is interesting.
Yeah.
All right, thank you. Just take care of the technical matter here. All right, so we have that before us. And so we have all of the issues before us, including those that Mr. Lawler mentioned that had valid affidavits. So I'll move to certify the issues presented.
Excuse me?
Oh, sir.
We need to, we need to certify the All-In Restaurant because there's another local
Okay,
option
that's
that's not.
what.
Oh, yeah.
Okay, that's what
They know.
we thought maybe it would have been an omnibus.
No, because these are not on the list.
Okay.
Oh,
The list is totally separate.
All right, good, thank you. That's what we were
So,
Yeah,
dealing with there.
That's it, separate signatures
That
then?
number, yes. That is the-
So I would ask that you accept the two signatures on the affidavit and
in Bay Village, yeah.
Yeah, Bay Village, yes, we do move that local option for Bay Village. Or like.
or what precinct we all.
All in restaurants, yes, we will. I move to accept those affidavits and validate that petition.
Okay, I will,
and certify it.
Certify it for the ballot, the November 5th, 2024 ballot.
okay, I'll second that motion as those affidavits were persuasive, given the signature and printed names on those affidavits.
Properly moved and seconded. All in favor, aye?
Aye.
The ayes have it, thank you.
So do we need to still, then we need to certify all the logistic questions or on this? So I know on the material that says certification of, oh, I'm sorry, I missed something in, but that's okay, strike that, I'm good.
You certify the Bay Village. Now we're gonna go on to the second one in question, which is the Cleveland 3, which is in Foster's. A little background, if you would go and look at the actual petition itself, which is the first exhibit. If you see below the line, it says shall the sale of it, and then you insert the following. Local options, if you see throughout that petition, below the line are your options to fill in. There are no other choices. Whatever is
Which
put.
exhibit is that, because I don't
Okay.
see it.
Exhibit
Oh,
A,
okay, exhibit A.
One.
Okay, thank you, yeah.
If you see below the line, all the way through the petition, those are the choices that are there, and whatever is put on that petition, by law, we have to put on the ballot. Can't deviate from it. So if you're putting an applicant for or hold their own, that's what goes on the ballot. As you can see, in this particular case, the petitioner listed that they were seeking the sale of wine and spirituous liquor. Wine and spirituous liquor is not a choice, it's wine. And
Wine.
beverages.
So as a combination.
So it's,
mixing
you
up-
can do beer, you can do wine and mixed beverages, and you can do spirituous liquor, you can do all three of them, you do a combination of them. But you can't mix it, you can't take part of one, as he did, and just do, wine and spirituous liquor, that'd be wine and mixed beverages.
So basically, you can't combine the classes of alcohol, you have to list them as it's stated.
Yes, with the quotes on, them, yes. So you have a choice, you have a choice of beer. You have a choice of wine and mixed beverages,
Yes,
and you have a choice of spirituous liquor.
right.
There is no choice of just wine. You have to have wine and mixed
Right.
beverages.
So in our materials, so on the language that, the notation that wine and mixed beverages is a single category. And it gives the explanation you're given, I guess, in a footnote. Both wine and beverages, you can't identify beer and wine or beer and mixed beverages or mixed beverages and spirituous liquor. That comes from the 2022 Ohio Liquor
It does,
Guide, Liquor Options Guide, Local Liquor Options Guide.
correct.
Is there any vetting by the liquor books for these applicants as, Yeah.
As far as the petition goes,
yeah,
to be frank with you, no, they don't care.
I mean, it would be so helpful to the people, the applicants, if they actually kind of did a preview and, to make sure they're putting the classes exactly the way they're supposed to be, as opposed to having it come here to us and then we have to be the bad guys to enforce what their own rules are, but I guess we do that.
In reality, the Secretary of State's liquor control is the Secretary of State.
Yeah, that's
It's not liquor control.
That's true.
There are things in the liquor control book that are not correct. We asked them to redo them, but It's like the D6 issue the board did last year.
Yeah,
I mean, that should be submitted to all the counties, let them know that, but they didn't update the book, they didn't tell anybody about it, so we're all kind of like waiting lists to go through
But this is not an issue that we're
it.
any
We've never seen this before,
for case of first impression.
so, I mean, Marcus, find that it needs to be both words, you can't just separate them out. And then the other issue is,
Give us-
they misstate what they're applying for on their holders up. Which also is not correct. I mean, you have to put, if you're a holder of something, you need to put down your holder, you can't make that you're an applicant for a D6 when you're actually a holder of a D6. Not that the public would understand what you're asking for, but that is what's being submitted to them, and so they need to understand, what's factual.
Thank you, sir. Mr. Musson, anything that you'd like to share with us?
No, I think, Mr. Lawler stated it correctly, at least my understanding of, 4301.333 B 3A. It describes what is required to be contained on the petition. It's not a substantial compliance issue, it's a strict compliance issue. And we've seen this with other petition requirements under Ohio law. And it says in B, the petition shall be signed by 50 electors and shall contain all of the following. And under 3A, it says the type of each liquor permit applied for by the applicant or held by the liquor permit holder as described in 4303.11 to 4303.183, including a description of the type of beer or intoxicating liquor sales authorized by each permit as provided in those sections. And if you look at the petition that was submitted, it does not accurately describe the liquor permits and what's authorized on those permits.
Thank you, Mr. Musson. Sir? are
Yes,
you
I'm here on
representing
behalf of Foster's.
From Foster's? Yes, please come to the podium and please state your name for the record and you may present to the board.
Thank you. My name is John Neal. I'm counsel for Imposters. I'm with Walter Haverfield here in Cleveland. Let's discuss this particular local option, if we will. A little bit of background before I get into the law. So the applicant is a performing arts theater and comedy club on Lorraine, in the 48th block of Lorraine Ave called Imposters. So they put on improv and sketch comedy and competitions. So they are in an area that had some dry restrictions. And so they applied to transfer a full liquor license to it from somebody else. So they applied to transfer a D1, a D2, a D3, and a D6 permit. And just by way of background, I practiced liquor law every day, practicing for 20 years. This is the stuff I live day in, day out. So I'm very familiar with this content. So the D1 is a beer license. D2 is a wine and mixed beverages license. D3 is the spirituous liquor license. And the D6 is the Sunday sales license, which allows you to sell wine, mixed beverages, and spirituous liquor on Sundays, which is separate. So when Imposters applied to transfer this license, they send in the paperwork. And as is standard practice with all liquor license applications, Ohio Liquor Control sends a request to this board to ask for an analysis of the voting records in the precinct in which the location is located. And that in fact occurred here. So everyone I'm sure knows Mr. Eddy. Mr. Eddy complied with that request, filled it out, and sent it back to Ohio Liquor Control. I have some exhibits that I'd like to pass around in this regard.
Let's go. Secretary.
Exhibit 1.
Okay, I was gonna make a joke.
Okay, members of the board, as you'll see, what this reflects is the original notification that Ohio Liquor Control sends to this board and the calculations that this board sends back to Liquor Control. And that's what tells Liquor Control what the wet, dry status is of any particular location. It's gonna have a liquor license. Based on that, Liquor Control sent back a letter to Imposters, the applicant. There is a copy. I think it's for-
Can we just ask a question about the first exhibit? Should there be an entry for, on the vote history? Oh, this is the vote history, location vote history. Okay, never mind, sorry.
Right, it's both. It's
Yeah.
actually the request and the response.
But where, I don't see the request then from your client then. Where would that be on here? Am I looking at the dates incorrectly?
Request from the client. You mean the
It's-
application?
the application, yeah.
That's a whole separate document.
Okay, so
That's not-
okay, the transfers are treated differently. So you're giving us then this why, as it relates to the imposters.
Because this is the foundation for what this board and what Liquor Control concluded in calculating the wet, dry status. And this impacts the selection that the applicant made on this particular ballot. This is the foundation for what's coming next. I have to tell you what Liquor Control has done, and what the official action has been.
Okay, thank you. Go ahead.
Okay, so based on that, you're now looking at Exhibit 2. This is a February 23rd, 2023 letter from the Ohio Division of Liquor Control to Imposters.
Are you guys marking these exhibits for us? I'm sorry, our clerks.
I have marked, I have.
Oh, they're marked for
I
that?
have stamped ones for him.
Thank you.
I'll give you this. So as you can see, this particular letter from Liquor Control tells Imposters that they're dry from Monday through Saturday for wine and spirituous liquor. Okay. So I'll take a step back. Monday through Saturday is one particular designation. And so what Liquor Control has said is that Monday through Saturday, you are allowed to sell beer and mixed beverages. You are not allowed to sell wine and spirituous liquor. And then Sunday is a little bit different. At this particular time, they were completely dry on Sunday. Okay. So that's what this board and Liquor Control determined what the wet, dry status is for this particular location.
Can you just explain to me how the board is determining the wet, dry status? Because that seems to be, how is the board determining the wet, dry status?
Sure. If we go back to Exhibit 1. On the 4th page of that exhibit, you will see 2 columns towards the bottom. And what that does, that's been completed by, as you can see, that's Mr. Eddie's signature down there dated September of, this one says September 22. So that's where this board tells Liquor Control what votes have occurred.
Okay, but how are we determining? So that's a different
We're not-
determination.
we're
We're not
not
determining dry and wet status. So just your characterization of that is, I think, misleading. So I just want to make sure I understand what you're trying to say about it, because this does not show anything about us making a determination about wet, dry status.
I agree with you.
Oh, okay, just to.
No, I'm not suggesting that this board
Okay.
makes wet, dry
Okay,
determinations.
okay,
What this board does is respond to an inquiry from Liquor Control.
okay,
That includes information that they have on the voting histories.
okay, there
And
we
if you look at the second page of this document, it actually spells them out from chronology. and it'll tell you what's.
We're in the business of precincts and, we're not in, okay, just so we're clear for the record, okay, I understand
Got it.
what this means.
Thank you.
So we filled out, John Eddie fills that out, we send it to liquor control, they dump it into the computer, and they match it up against votes during those times, and then they determine what's left or out.
Thank
I
you,
got you.
okay, thank you for that.
Yeah.
Okay, so with that foundation, I'm gonna pass out exhibit 3. This is exhibit 3. Okay. So exhibit 3 is the actual liquor license that was issued. So after this board gave its information to liquor control conducted its analysis, they issued this liquor license. And what I'd like to direct your attention to is the middle of the page in the column where you see the class or code of liquor license. So you see D1, D2, and D6 there, right? And so when you look at the D2 license, and that says that the imposters is that license allows them to sell wine and certain prepackaged drinks for on-premise consumption and in safe containers for care. Now, if you go a little bit further down, you'll see a line that says sale of wine illegal. So what has occurred here is that liquor control has determined that this, based on the information given to it by this board, that this subject location is allowed to sell mixed beverages, but it is not allowed to sell wine. I think Mr. Lawler, when he was presenting, indicated that this is an issue of first impression. I'll indicate something similar. I've been doing this a very, very long time, and I've never seen anything quite like this myself. This is a first for me. So what you have is somewhat of an anomaly, but it's an anomaly based on the particulars of the votes that have occurred in this precinct at this address over the prior years. So with that background,
Can I ask you a question about this exhibit 3 here?
sure, yeah.
So why would we see a permit that allows the sale of wine under the D2 class,
Mhm.
but then we see the notation that the sale of wine is illegal? I'm just not understanding what their intention is
Well,
there.
trust me, it's not intuitive. I agree with you.
I mean, it doesn't make sense. Either you're permitted to sell wine or you're not, based on the permit that's being given, unless there's some distinction between certain pre-pack. I'm a teetotaler, so I don't drink, so this is all crazy for me.
After this,
I
you'll
don't
change.
drink. But anyways,
So
yeah, what
there's
does
a-
that mean?
The issue is that under the D2 license, a D2 license allows a permittee to sell wine and mixed beverages. So the D2 license allows you to sell both wine and mixed beverages. And that's right in the code.
So my question is, why then do we have the sale of wine as illegal?
Because they're giving the D2 permit, because one half the D2 permit works. The mixed beverages portion of the permit works. So Imposters is allowed to sell mixed beverages Monday through Saturday. What they're not allowed to do is sell wine. And that is a function of the votes that have occurred in this county, in this precinct in the past.
So when was this issued? After, because why would they then submit, why do we then have in front of us the application that says wine and spirits? This is really the heart of it. I know you're giving us the background. I don't mean to preempt your presentation, and I will be quiet, but for me, the question is the petition filing invalid because there is a mixed class put here, or,
Absolutely not.
okay, so why do we have, if they were already approved to sell wine?
They're not.
Okay,
That's,
okay, all right, I'll be quiet, let you finish.
no, I just didn't want, I didn't want to complete that hypothetical. They are not allowed to sell wine, but they are allowed to sell mixed beverages. That is the function, that is the effect of this liquor license.
Is that the D2
Yes.
permission? Okay.
Yes. And interestingly enough, and this is just, I know you, I don't want to bog us down with too many details, but it bears mention within a Ohio Revised Code, section 4301.01, that's the definitional section of alcohol. Wine is one separate definition. It's very long, but the long story short, it's got something to do with percentage of alcohol volume made from grapes. Okay, that's what wine is. And then in paragraph 4, right below it, is mixed beverages. So mixed beverage, and I will read this. Mixed beverages include bottled and prepared cordials, cocktails, highballs, and solids and confections that are obtained by mixing any type of whiskey, neutral spirit, brandy, gin, or other distilled spirits with, or over carbonated or plain water, pure juices, flour, plants, and other flavoring materials. Okay. So wine is something that's made from grapes, and it's a separate definition under the law. Mixed beverages is something you mix with another spirit. Let's just call it, a margarita. That's a mixed beverage. Okay. So they're two separate things as defined under our law. So this liquor license allows imposters to sell the mixed beverages. They're allowed to sell, margaritas that they make up, provided they're within the alcohol proof limitation. And they're allowed to sell margaritas and low proof. They're allowed to sell mixed beverages, but they can't sell wine. And that's exactly what this liquor license says. So.
But, okay, so just
Go
go
ahead.
back. So underneath the sale of wine is illegal, it says, and I'm assuming this is an abbreviation, pure spiritus liquor from agency. There's a reference to spiritus liquor there. What does that mean?
That is the instruction of the permit holder on where they have to buy their hard liquor. So that each liquor, any retail permit holder in Ohio is assigned a singular state agency from which they have to purchase their hard liquor or spirits.
Okay,
So that, all that is a notation.
okay, that doesn't matter.
Yeah, it means nothing to us right now. So,
Well, I have a question.
yes,
On the petition application, why on that line 1, it's the sale of wine and spirituous liquor when they already have spirituous liquor? Like,
we don't have spirits. That is the D3 license, and if you'll see, the D3 is not on.
okay,
So,
gotcha.
so back to the member's question here, why is there this purchase spirituous liquor from agency Minotti's on there? That's really just surplus.
Right.
It's kind of automatic language.
So counselor, in your years of experience in doing this work, and I know you've already said this is a little bit of an anomaly and something, but fundamentally, can applicants on liquor applications combine classes of alcohol in the petition, in the application?
Yes, and they're allowed to select. It says right there in the statute. I have a copy of the statute for you, because the particulars of the statute are what direct us here and guide us more than anything. And I understand that we have a Secretary of State manual that says something a little wonky, a little different, and we're gonna get it.
So, yeah, so that's the question then. So in your view, you can combine these classes of wine and spirituous liquor? Is that what you're getting to, or?
Yes, and we routinely combine them. So you routinely see liquor license local options that are beer and something else, beer and spirituous liquor, or maybe just the wine and mixed beverages. And the
Well,
reason-
But in the
Does it say
license,
beer?
go ahead,
Yeah,
sorry.
beer and mixed beverages, do you do that? Is that permitted?
What it's dictated by is the wet and dry status of the location. And like I was saying, I've never come to a situation like I have today, where I have a location that is allowed to sell mixed beverages, but is not allowed to sell wine. That is a first.
Okay.
I agree with that.
I'm sorry, could you repeat that?
Yes, what he was asking is, have I ever mixed beer and mixed beverages? And the answer is no, because this is an issue of first impression. And it's dictated by, not by me. This status is dictated by the votes that have occurred in this board, governed by this board at this location.
But the votes are presumably based on petition language that was clear and reflected the separate classes of.
That's a great point. And so, to your point, back in the day, somebody had a local option petition for wine only and not mixed beverages. Otherwise, we couldn't be here. So that's the irony to this whole thing, is that the position that's being advanced is that this petition is invalid because it says mixed beverages, and it doesn't say wine and mixed beverages. In the past, somebody ran a local option over wine only. That's why we're here. That's why this scenario exists. Otherwise, we wouldn't be having this conversation.
Well, it says that I know your argument is, I don't know if the statutory language is any clearer. But this note on the guidelines, and I don't even know how an applicant would even figure out how to apply, given the, sort of this discrepancy here. But the note says, wine and mixed beverages is a single category, requiring both wine and mixed beverages. Thus, a petition may request beer and wine and mixed beverages, or wine and mixed beverages and spirituous liquor, but not beer and wine, or beer and mixed beverages, or mixed beverages and spirituous liquor. And I guess we are deducing that it can't even say wine and spirituous liquor. Because is that the issue? The classes are not as specified here. It's confusing.
Well, so you're saying, just so I'm clear too, piggybacking off her question, the fact that mixed beverages wasn't included because it's the statutory package is what, on the language is our problem. But you're saying they had mixed beverages, so that's why it's not on there.
Bingo.
Okay,
The law allowed this applicant to sell mixed beverages. That's undisputed. They're selling them right now. They have a liquor license to do that.
under that permit, which would have permitted wine, but because of the pass vote, so it's like part of the permit's just not going through.
Yeah, I agree with
Okay,
that
all right,
characterization.
All right,
So what you have is a scenario where, let me pose a hypothetical to help answer this question. What if I wanted to run a beer local option? So I got a petition and I was asking the voters to vote me wet for beer. But my location was already wet for beer. This board would look at this and go, you can't run a local option and ask for a remedy for the voters to give you the right to sell beer when you already have it.
That's not true. The board doesn't make that determination.
Yeah,
If you want to put it on the ballot as a beer, we can do that. We've had that. This is, that's one thing I want to bring up. We've been told by Liquor Control and Secretary of State, like if you had questions 1 and 2 on the 5 hour, which is weekdays and Sundays, you put them both on there, but you're already wet for the weekdays, and you put it on there and it fails, you don't lose your license. That's what Liquor Control and Secretary of State has told us. So I guess my question is, you already have mixed beverages. Why can't you put wine and mixed beverages on there, and if it loses, you still have the mixed beverages?
That's where I disagree with you, but that's wrong. If you put something on a ballot and you lose those privileges. So if I were to put wine and mixed beverages on this petition and it gets voted no, my applicant just lost a right that he had. Now that's,
and the law doesn't require the doing of a vain and useless thing. So if you mean, why would you, if I were an applicant, I wouldn't necessarily put on an application for a new permit, something I already have, but hey, can we get, I don't understand,
So if you go back to Exhibit E, which is revised code 4301, 355, and it's highlighted, and that's the form of the ballot, when it says, and B, at the election, one or more of the following questions, that the ballot petition shall be submitted to the electors in the precinct, shall sale of insert wine and mixed beverages and spirits liquor. So the form of the ballot is in the revised code. So maybe the sections of the codes are converting against each other, but the code, as far as the board of elections, as far as my department's concerned, is very clear that these are your choices, that it says
Yeah.
shall, shouldn't be.
Okay.
And it's in-
Thank you, and Mr. Neal, in the interest, I think we've heard a lot of information.
I think he's got a
we
handout.
have, you have another handout, we'll take one more handout,
Yeah.
and then I'm gonna ask,
What is this?
Mr. Messenger, say, give us a wrap up, and then we're gonna wrap this up, thank you.
That's
Oh,
very good. I just need to make my record.
Please, no, that's fine,
This is very unusual.
yes.
I have one more question.
Yeah, one more question.
Can
One
we
second,
can
it's
we give a final,
Yeah, please.
Attorney Neal, give a final statement, so we were really clear about what you've given us a lot of history here, but what is the crux of the argument you're making?
So it begins with what I just handed you, which is exhibit 4.
Okay.
Exhibit 4 is a copy of the statute,
Yeah.
4301.
You all get this statute?
No, from this one.
Yeah, we actually have this in here, right?
Great.
Okay.
So
It's our exhibit E, I believe.
Yeah.
if we come down to section B1. It says, shall the sale of blank, insert beer, wine and mixed beverages, or spirituous liquor be permitted by. What that doesn't say is that the applicant is required to choose these as particular categories. That's not in the statute. So what it allows the applicant to do is pick what it sees here and put that on the ballot. That's what the statute says. Now, I understand that the Secretary of State has issued a manual, and I've got it, well, you all have it as well. I have it as an exhibit, but I'll spare us the time. And what I will point out to you on page 16 of the Ohio Secretary of State's manual, it talks about generalities, right at the top, generally. Generally. And then it says, no, wine and mixed beverages is a single category, but there's no citation to any authority at all. So what this basically is, quite honestly, is a rule, this is an advisory, this is a rule of thumb for boards to deal with. It would probably cover 99% of the scenarios in which they encounter. This is that 1% scenario that is not encountered.
Yeah,
Now, I understand the ballots all say choose one category. Well, that's not what the statute says.
but the statute doesn't say, I mean, if we're gonna read the statute in the plain meaning of the statute without carving and mixing, sort of slicing and dicing it the way you are, I would make an argument that the statute is more or less clear that you have to pick these in the parenthetical, these are the categories. So you couldn't mix wine and spirituous liquor, you would have to insert either beer, wine and mixed beverages, or spirituous liquor in your application.
Right, there's an and there, and the or, you know, and they're separated.
Yeah,
To me, it reads and, as if it's one category, so I guess I'd have you speak to that. And then I had one final question, I'll just put it out there now. There was also an issue with the fact that the holder of the D1, D2, and D6, and an applicant for D3, but that, that's, you know, I'm not clear. This is the applicant for D3 and D6 and a holder of D1 and 2. And we've had some past dealings with that needing to be strict compliance, so I guess those are my two final questions.
Sure, may I come to those again?
Sure, absolutely, I just want to put them out there.
Okay.
Thank you.
Thank you. So I would submit that when you read this statute does not say you have to choose wine and mixed beverages together. That's something that has been inserted by a notation in the Secretary of State's manual later.
but would it make sense for the classes to be stated in the application as they are identified, as opposed to mixing? But the way that parenthetical in those classes are stated is as they are stated in, you know, there's no separate class that is just wine and spirituous liquor. So would you think that it's a fair argument to read into, or that it's implied in the reading of the interpretation of the statute, that the applicant has to list what they're applying for in the way it's listed in the classes and then in that current parenthetical? Is that a fair argument?
No, I don't. And because the statute doesn't say that you have to pick these exactly as it does not say, you have to choose wine and mixed beverages. And we know from decades and decades of history, you can pick a selection of these products and have them on your ballot.
But we've not had wine and spirituous liquor.
True.
Okay.
Well,
Well, we've already agreed that this is an anomaly.
Well,
We don't
yeah.
precedent.
Well, I wouldn't say I've never had it, but it has occurred. And that's what I said earlier,
Right.
because it has voted that way in the past.
I think that's what it is.
Or we wouldn't be here. Somebody voted down wine.
Yeah.
But not.
Right?
Yeah, right.
Mr. Muslim?
Yeah, it looks like in 1971, it dried up wine and spirituous liquor. Is that what I'm reading correctly
Is
here?
that an exhibit one you're looking?
Yeah, exhibit 1.
That's right. Dried up wine.
What date is that? What date
It
is
looks
that?
like 1971,
Oh,
it
okay.
became effective. I don't know if the vote was in November 4th, 1969. Is what I would understand that to mean.
I would agree that that's roughly around that's when the vote occurred and when it was certified some short time thereafter.
So was there a change in the law that described what these permit designations authorize?
Not that I'm aware of.
No?
But see, and we're in a little bit of a predicament because we have effectively our chief elections officer, our secretary of state in this agency interpreting the statute. I mean, I don't know, you're saying the statute doesn't say they have to select and, you know, they can't select and mix and dice, but it seems like we have guidance that says they do.
What I would suggest the board has is guidance in general, because that's what it says. The Secretary of State manual even says right at the top, generally. And this is an unusual case. And it's an unusual case because of the history where somebody voted wine only dry, but left mixed beverages alone. So that in and of itself kind of defeats the whole concept that these have to be together. Because the law, as it exists for imposters in this precinct, is they are separate. So imposters cannot ask for a legal remedy for something that it already possesses. That's a fundamental tenet of jurisprudence and law. You can't go
So
to,
why is it even applying for something that it already has?
we're not,
Everything.
we're applying for wine and spirituous liquor. That's what we don't have. We have mixed beverages. So we left,
So you're trying to create a complete permit, which gives you both parts of it.
yes, we are trying to complete it. We are trying to create a complete permit based on this very unusual voting situation in this particular precinct. And if I were to come back and if I were to submit a petition that said wine and mixed beverages, I already have mixed beverages. That's a legal flaw in and of itself. That's asking a remedy for a situation that already exists. If I were to, so this is a catch-22, if you will. You know, I'm being told, well, no, you have to ask for wine and mixed beverages, even though you already have mixed beverages. But if I ask for mixed beverages, which I already have, I'm violating well-established law. Now, what I would suggest is.
What is the law? What's the case? What, are you a case or legal reference for that? You're saying, what law are you violating?
The concept of standing and.
What
having-
law, you're saying a concept now, what law are you violating?
The concept of standing and having an actual case in controversy.
Yeah.
And citation for that particular theory, but that's a fundamental tenet of law. You can't go to an administrative agency and say, give me something that I already have. The agency will say, you're wasting our time. We don't do that. This isn't an exercise, we're not playing around. So that's the concept, is I have asked for exactly what I need and nothing more.
So why wouldn't your applicant, your client have simply submitted more than one application then? Under your theory, they could apply for wine under an occasion, and then also spirituous liquor under an application. I mean, it seems to me, everybody always comes to us looking for us to fix it and figure out the remedy. And oftentimes, you know, the applicant or the complainant is the person that really can, you know, fix the problem before it even gets here. I'm just wondering if you have in your past, or even in this case, would have an applicant make application for more than one, you know, category. If you
Separate petitions?
yeah, would they do that? And would that avoid some of the problem?
Well, no, well, I've never done that, so I speculate what would happen. But the issue would remain the same, because the position I'm being given is, if you don't say wine and mixed beverages together, in quotes, your petition's invalid. So if I said one that said wine only, I'd be getting the same position, right? Which is, well, this doesn't say mixed beverages too. So that's the answer to that. But what I'd suggest, in the broad overall scheme of things, and I know, I'm being asked to wrap. What I would basically like to submit to you is that the Secretary of State's manual is not perfect. It is advisory in many instances and guidance in many instances. In this instance, it is advisory, which probably covers 99% of the scenarios. I get it. But in this particular case, it is not instructive. It does not apply. And so, ironically enough, right before I walked up here, I heard Mr. Lawler say the Secretary of State manual is wrong a lot. It's wrong last year with the D6s and wishes that it be updated. To be frank, it's just incomplete as to this particular scenario. This is not wrong. What we're doing here is really exactly what the law requires. And if I were to do it differently, I would have a whole different set of problems. About no standing, no case and controversy, asking for something that the law already gives me. So that's where, and so in terms of the Secretary of State's manual, I was here a couple of years ago for the Harbor Bay case, and that was a case of undercounting and overcounting, and this board probably remembers the Supreme Court's Rust decision. And basically, in the Ferrara case, which was decided in 2002, the Supreme Court of Ohio basically overruled, basically said the Secretary of State's manual is wrong, and it doesn't cite to any authorities. And that being the case, that's not the law. We're guided by the statute. And the statute does not say that I have to pick these in categories together. Yeah, in the Ferrara case, it's citing the manual, the Trumbull County Board of Elections on page 2. They were very clear that the part petition must be invalidated, citing the Secretary of State's manual. Page 4, the Supreme Court replied, there's nothing in the statutory text that requires part petition to be invalidated for such a mistake. They reject, in the Ferrara case, 2002, the court rejected the reliance on the manual where the statute did not support it. And then they also cited a prior Schwartz decision where the court cautioned against making decisions which are too technical, unreasonable, and arbitrary. They actually called the Secretary of State manual on page 6 of this public. That's the Supreme Court 2 years ago.
What's the word? I'm sorry.
Befuddling.
My concern is, we get Secretary of State. I mean, that's a good quote, and, it's instructive in some ways. My concern and my reluctance to, move in a direction different than what is being recommended by our council and our staff is that we have to follow, and in large part, we get advisories all the time from the Secretary of State. And I mean, who are we to be saying, one is ill-founded, one is befuddling, or one is, that's for a court to say. In my view, we are bound by, and we are to be following what our chief elections officer is telling us to do. And I think the interpretation of the statute, you have a persuasive argument that it should be read, so it doesn't maybe require the specific categories to be enumerated, but that's, I think there's a fair reading on the other side. And so we would need, at least I would need probably legal authority to tell me that that's the way I should be interpreting the statute. And whether perfect or not, the Secretary of State's advisories are the Secretary of State's advisories, and we follow Secretary of State advisories on many fronts. That's just kind of where I'm coming out on it.
Yes, Mr. Nolan.
Joe, you made a comment about separate applications. The other method, as far as I believe, is going into this knowing that they were drawing for half of that. The 5-hour petition is a specific location. They could have gone on a petition for wine for the precinct and left the precinct itself, and that would resolve this issue. But there was another avenue available to them, just so the board understands that, if they chose to do it. And the signature requirements would be exactly the same.
But nevertheless, they would still, they would still have to choose between wine or wine and mixed beverages on a precinct.
Yeah.
Well, thank you, Mr. Neal. Anything else for Mr. Musson and Mr. Lawler?
No, I just keep going back to what's required by the petition, or what's prescribed to be contained in the petition in 4301.333 B, B3A, which is for purpose of this section or division, use means all the following, and it's the type of each liquor permit applied for by the applicant or held by the liquor permit holder, as described in the sections that classify those permits, including a description of the type of beer or intoxicating liquor sales authorized by each permit as provided in those sections. Somehow we got a disconnect between what was dried up and what's permitted under the liquor license that were issued. So it's an anomaly that, I'm not sure how we got to this point.
Do we have a discretion? And I mean, I'm not,
I have discretion.
yeah, do we have any discretion to?
That's the question.
I mean, council's arguing, the generality issue in the manual, but the issue would be discretion, whether this body has discretion to do something, that might be different. I'm not convinced that necessarily, but the discretion question may get me in a different place, I don't know.
That's the question for me.
I'm not aware of any case law that's directly on point under this section, but as a general proposition, these mandatory components of a petition are strictly implied or enforced. So I don't see a lot of discretion in the statute.
Mr. Musson, for Mr. McCaffrey and I, we're two non-lawyers.
Sorry.
If we want to boil this down to its least common denominator. In order for this to appear on the ballot, the question has to be legitimate. And therefore, you're basically saying the question that's being presented is not necessarily a legitimate question for the voters to consider.
It does not seem to fit within the template for the ballot language.
My only response to the non-lawyers is that the statute does not say choose one of these three categories, and we are guided by the statute. All of us, Secretary of State notwithstanding. And again, this is an anomalous situation, and the only reason we're here is because in the past, somebody split these two wine and mixed beverages up. So I wouldn't be here.
Right, yeah, we certainly understand and appreciate your time, Mr. Neal, and your presenting this before us, and Mr. Lawler, you and your staff for the work that you've done. The board, I believe, has the question before us, and we can now deliberate. Thank you, gentlemen.
Thank you.
Thank you for your advocacy.
Appreciate it, yeah.
Thank you.
Board, we have heard recommendation of staff. We've heard from Mr. Neal. Any other questions before we move on the petition?
Yeah, I say I'm struggling a little bit, but honestly, I don't want to be the one setting precedent. I do think, statutes can be interpreted in different ways, and, I think there's a good interpretation on, that's been offered today, but I think that just because the statutes don't say it, something expressly, specifically, there's implied language that, or there can be inferences made. I feel compelled to follow the Secretary of State's advisory, as council has identified it in the language in the manual. It does. Because that's an anomaly, but until I get some court guidance or some other guidance, I would be inclined to say that petition filing is invalid and not have it certified to the ballot.
Thank you. Any other comments?
Yeah, if I'm looking at the 4301.355, that revised code section, I look at sale of and the options, insert here, it's comma, wine and mixed beverages, comma, or. So to me, it is a category. Your argument makes sense. It's like a common sense argument where you have one but not the other. The problem is, you know, it seems through advice of our council as well as the manual, this is sort of a strict compliance. And I don't feel this board does have the discretion, but I think you do have, you have made a compelling case. I just am struggling with the statutory language, so given that, I'm agreeing with my colleague.
Thank you. Mr. Captain? And I concur with our fellow board members with their assessment, so I move to reject or deny the petition from Imposters Limited and not certify it to the November 5th, 2024 presidential general election ballot. Second by Ms. Chappelle. All in favor, aye?
Aye.
The ayes have it, it is so ordered. Thank you, sir. On to election officials, we received an updated PEO. Yeah, I'm sorry.
Could you certify the remaining issues?
I'm sorry, thank you, there was so much.
One question too on that, certification of the, oh, I'm sorry, looking at the wrong note here. Yeah.
No, I'll move to, thank you, Mr. Mullins. I move to certify the issues for the November 5th, 2024 presidential general election.
Second.
Second by Ms. Chappelle. All in favor?
Aye.
Aye, ayes have it. Thank you so much. Election officials, Ms. Marlene Robinson Statler.
Good morning, Martin Robinson, Statler, Manager for the Election Official Department. Presented you with an updated version of our precinct election official policy, performance review policy. And just wanted to talk briefly, we use this policy to do as a monitoring tool for the hiring and of precinct election officials and for training. And just some updates that we made, because I know it's come up previously, is we did clarify the definitions of promotions, demotions, and on watch within the performance review. And we also separated a question that we had previously in there that was when the precinct elected officials opened and closed on time. We separated and made two questions. One, opening on time, and second, opening equipment on time. Because there had been questions within even the election officials that work with the managers and so forth. If I have open on time, I didn't open my equipment on time, so we did separate that out and detail the information, and then followed any updates from our election official manual from the Secretary of State.
Thank you, Ms. Statler. Any questions from the board? I believe some language is updated to reflect the new equipment.
Yes.
Yes, that was
Yes.
right.
Yes, exactly. So we got rid of all the citations to the ESNS equipment now replaced with critical.
And we got this red line a while back. Did we get a red line in this a while back? Yeah.
All right. Thank you. I move to acknowledge the updated PEO performance policy.
Second.
Second by Ms. Chappelle. All in favor, aye?
Aye.
Aye, the ayes have it. Thank you so much. All right, under fiscal services, Mr. Pilati, anything that you need to add? We do have this information before us.
Sure. I'll just make two quick comments on 9, letter A. That's for 25 computers. Secretary of State. One of the grants that we received is a cybersecurity grant. And one of the requirements that is in that is September of October of 25, all computers need to be operating on Windows 11 operating system. Currently, all of the computers that we utilize in the vote by mail process all our computers operate on Windows 10, but those computers not able to be upgraded to Windows 11. Everything works fine now, but by the time next year comes around and we have our next biannual budget, it's prior to that deadline. So talking with the Secretary of State's office, they qualified this purchase as a qualifiable purchase with the grant dollars. So we'll pay for it that way, and we now to bid as required. And so those will be coming and be installed for use for the November 5th election. And then, is there any questions on letter A? Okay, letter B is our standard voter information guide that we send out to voters. That'll be going out to households. That will set sail. We're getting this one out a little bit earlier than we typically would for an election. One of the things we want to point out to individuals is that they forget, understandably so, that in even year general elections, the Secretary of State sends out an application, so we're looking for that, and that is good, legitimate, and please use it, to vote by mail. So, we are doing that, plus we highlighted or underlined bolded in a couple spots that the early person voting is at 2925 Euclid. It is not another address I won't even say to confuse anyone, so we want to make sure people understand this is where they need to come vote, early in person.
Thank you, Mr. Chappelle.
Thank you. And this is for 493,000 guys. Is that the normal event in this region? Do we normally spend that, about that amount?
Yes.
Seems like a slight decrease or no?
Probably about 2 years ago, we started sending to households instead of the individuals, because like, for example, I would get 4 in my household.
Right,
And I
okay.
would just get 1. And then also what we, by doing the households, a benefit to that, besides fiscal, but is that even if someone moves, it's to the voters at that address. So if someone is there and so that it's that physical property, this is where you go to vote. And so that kind of is helpful too.
Thanks for that reminder.
Thank you, Director. So we have, 2 resolutions before us for Giltex and Weeklies, and I move to approve both of those, resolutions as presented.
Second.
All in favor, aye?
Aye.
The ayes have it. Thank you. Going to registration, Mr. Pilati, if you tee this up, and then the chair will recognize Mr. Wheat.
Sure. So we're gonna, there are 4 items under registration. First 3, numbers 10, 11, and 12 are challenging of addresses. They are related but filed by different individuals. Number 10 is a challenge filed by Mr. Grisham, and number 11 and 12 by registration manager Sonny Wheat. They all relate to the same street address. And so Mr. Grisham came forward with a registration challenge. Received, and we've had this before, we had it at last meeting. I got a confirmation notice to his residents, said this person doesn't live here. And so he filed that. Now, when we got that, we were able to connect with Levon Thomas. And he said, yeah, I don't live there. And
Said he never lived there.
never, right, and he was going to go ahead and update his address. So we put that challenge in abeyance to give him the opportunity to do that, but after a month, he didn't come forward and change his address. We were gonna go forward with the hearing, and so we're here. In the meantime, 2 additional cards came in for that same street address. Same first name initial, same surname, same date of birth. So some things that just, enough where science and his staff processing go, this brought it to Tony and my attention, and let's go ahead and challenge that. And so they are 3 separate challenges to be handled that way, but there is that relatedness to it.
Yourself. Thank you, sir. Mr. Wheat.
Good morning,
Morning.
Asani Week Registration Manager. You should have before you a Form 257 challenge of the right to vote and correction of registration lists that was submitted by Brian Gresham and received by the Board of Elections on May 29th, 2024. Mr. Gresham, a registered voter in Cuyahoga County, is challenging the voter residency of Devon Thomas. Mr. Gresham noted in his challenge that Mr. Thomas does not live at 20508 Hanson Road in Maple Heights, Ohio, nor has anyone lived there by that name in over 25 years. The voter registration database shows that Devon Thomas's most recent registration had him registered at the 20508 Hanson Road address since May 1st, 2024 via a voter registration form from Blackbook Strategies. Mr. Thomas was contacted by phone by CCBOE staff on May 29th, 2024 regarding his voter registration. Mr. Thomas stated in the phone conversation that he has never lived at the 20508 Hanson Road address and that he currently lives at 4705 Walford Road, apartment 6 in Warrensville Heights. A voter registration form was sent to Mr. Thomas to update his address. However, Mr. Thomas has not updated his address back to 4705 Walford Road, apartment 6 in Warrensville Heights since CCBOE staff reached out to him on May 29th.
Yes, Mr. Pell.
Asani, when you did a conversation with Mr. Thomas, did he say why he signed if he didn't live at the Hanson Road address? And did that come up? I mean, was he just presented with a card? Was it already built in? I mean, I just don't understand if he never lived at the Hanson Road address. To me, it would indicate that he didn't write that address there.
Right, he didn't not, go into any detail and ask, he didn't really give, much of a reason why, if at all.
So we just assume he signed, but he did not handwrite the address.
That's correct.
And it never voted one way or the other.
Correct.
Thank you, Mr. Weed. Is Mr. Gresham here? Mr. Gresham? Or a lawyer representing Mr. Gresham? All right, not on Zoom, not in the meeting. And we'll ask, is Mr. Thomas present or a lawyer representing Mr. Thomas? Neither are present. For the record. Any other questions for Mr. Weed? All right. I move to uphold challenge filed by Brian Gresham against Yvonne Thomas and to cancel his registration.
I'll second that motion.
All right, all in favor, aye? Aye, the ayes have it. Mr. Beach?
All right, so I'd like to bring you to the attention of, David Thomas and Dave Thomas, so the next two items. So you should have before you two Form 257s, challenge of the right to vote and correction of registration lists that was submitted by Asani Wheat and received by the Board of Elections on August 9th, 2024. Mr. Wheat, a registered voter in Cuyahoga County, is challenging the voter residency of David Thomas and Dave Thomas. Mr. Wheat noted in his challenge that David Thomas and Dave Thomas reside at 20508 Hanson Road in Maple Heights, Ohio, which is the same address that Brian Gresham had challenged the voter registration of Yvonne Thomas. Mr. Wheat also noted that after review of the voter registration cards on file for Devon, Dave, and David Thomas, all three registrants have the same surname, address, and birth date of February 8th, 2000. The registration card for David Thomas was received from the organization Blackwork Strategies via a registration drive and was processed on July 2nd, 2024. The registration card for Dave Thomas was received by the organization Second Street Associates via a registration drive and was processed on July 22nd, 2024. The registrations of David Thomas and Dave Thomas were put in an inactive status due to routine SOS and CCBOE quality assurance measures that were unable to verify relevant voter information through the BMV SSA verification processes. CCBOE staff attempted to reach Dave Thomas and David Thomas, but were unable to get to either individual.
Thank you, Mr. Reed, and I'm not a handwriting analysis expert, but the signatures look very similar on both of these copies.
Yeah.
Just stating that for the record.
And these cards came in after you had already contacted the first Mr. Thomas.
That's correct.
Okay, so I'm just for our timeline. Okay.
And the probative fact and concerning fact for me is, we have three people with the same birth date, birth name.
Same last name, right?
Same last name, same, so, you almost wonder if whoever's circulating this is just creating, names based on the derivatives of. It's just very concerning, I mean, the same day of birth is really telling, about these three registrants, alleged. Registrants. Anyways,
Thank you, Mr. Weed. Is Dave J. Thomas or an attorney representing him present or online?
or they're all three ego, oh, excuse me.
I need the Thomas.
Here, is David Thomas present or attorney representing him present or online? All right. Neither Dave or David are here, so therefore we'll take these separately. I move to uphold the challenge filed by Asani Wheat against Dave J. Thomas and cancel his registration. Second by Mr. Bell, all in favor, aye?
Aye.
Well, have it, and I move to uphold the challenge, filed by Hassan Weed against David Thomas and to cancel his voter registration.
Second.
Second by Ms. Chabelle, all in favor, aye.
Aye.
The ayes have it. Thank you.
I had a question on that. Normally, I know we refer usually these agencies or circulators. But I mean, would this be an issue where this person was notified and, I mean, they know they don't live there, there's concern on signing a card, but to your point, we don't even know if they were just presented a blank card or not. I mean, would this be an appropriate thing to do a referral on as well? Because there are those pretty serious questions. To see whether one, this is someone who is doing things they shouldn't be, or two, someone who's being taken advantage of. Either way, I guess and this is now 3 cards with the same arguably person on it.
Or have you had the discussion with the 2 agencies about these?
Yeah, yeah.
Well, I think that leads us into where we're going.
Well, yeah, and I know we're gonna also talk about those entities that are circulating. To me, that's also a separate concern on this individual, whether they're purposely signing these or maybe being taken advantage of, if it's someone who's not understanding what's going on. So just my 2 thoughts, and maybe that's more appropriate to bring into the next conversation.
Maybe they're not even signing.
Yeah,
Maybe
fair, that's fair too.
Yeah, like,
So,
yes.
right, yeah.
Does that cancel this person's Warrensville Heights address? I would assume it would, because they changed their registration. But this person hasn't voted as well, I see.
Right, so as far as, the bond,
The initial, yeah,
Right, he does not have a voter registration, he changed. I'm not saying, it was changed.
It was changed,
From Warrensville to
right,
Maple,
right.
and then, and so there was no more Warrensville, the Maple was the registration of record, and now that's canceled, so that the Vange does not have any active registration.
And he can come in to update it to the address he claimed he lived at.
that's right. And also we did have personal contact. So, I mean, okay. I mean, that part of it, but just then, I guess if we want to bring that into the next conversation, I just have a concern about maybe either his conduct or at least him being potentially taken advantage of.
Well, the danger would be, in this case, if you were registered, and somebody had a fraudulent card at another address, which negated your registration.
Yeah,
If you hadn't reached, in this case, you were fortunate to speak personally, but it could happen somewhere else, you could.
it's just that if this person
speak out.
if this person was advised by us, admitted they didn't live there, and then 2 cards come later, that's where, and I understand we're gonna talk about those agencies involved as well, but I just wanna make a note of that as well.
But it's very concerning, and that does lead into, the next agenda item,
Okay,
13, which is a discussion on personal registration cards. So we, at the previous board meeting, when we did cancel, first, similar back pattern in that someone lived at a house for a long time, Miss Kane, we went in and we canceled that. And, I had indicated that we would be talking about it today, and we're going to, we got through our statewide petitions and we're able to put a little bit more focus on this, because we're getting cards on a regular basis from 2 main, circulation organizations, Second Street and Black Fork. And really, we've identified at least 3 categories that are of concern. And we want to talk about those, today, and we're also, this is something that we're hearing from our counterparts at other boards of elections across the state, so.
great.
This does not seem to be a Cuyahoga unique thing. This seems to be, various pockets, if not the whole state, at least pockets in the state are dealing with this. And so, Tony Gallagher and Sani have done most of the heavy lifting, putting together some information to go ahead and talk about what we're finding, what we're seeing, and update the board on that, and then to see, what, where do we go from here? So I think with that, so I'm gonna hand it off to Tony, Director Gallagher, Deputy Director Gallagher, and
Well, thank you. I guess the first category that we're talking about is this homeowners challenge, where homeowners are so the way that the process works, just as a refresher, once somebody registers to vote or updates their voter registration, we have a postcard that we send to that household to for one, for the individual who lives there to get their information as far as what their current polling location is, their district information and so forth. That also acts as a mechanism to help verify that the individual actually lives there. In one scenario, well, in these, typically what would happen is the voter who lives there would receive it and get that information. Potentially, if the card comes back returned undeliverable, then that person would be marked as a must vote provisional in our voter registration electronic poll books, and they could go to the polls. And at that point, they would have to provide the information so that we can confirm that they actually do live at that address. In this case, what we've been seeing, what you saw at the last meeting, this meeting, and we do actually, there were some people who were inquiring about additional challenge forms 257, which haven't come to light yet, but potentially could be at the next meeting, where the individual who does live there receives that acknowledgement card and states that this person does not live here, and therefore brings it to the board's attention, and our board takes action accordingly. The next scenario that we have, which you can see, this was a handout that we provided on your basket, has looks similar to this, two registration cards like this. Through our various checks and balances that are in place that this Cuyahoga County Board of Elections Registration Department uses along with the Secretary of State's office, it came to light that 3 deceased individuals were re-registered by Black Fork Strategies and another one by Second Street Associates. The first card in question is regarding Ruth, I'm just gonna say P. Ruth, you look on your second page, Ruth passed away. So at the top of the form, you see that right there. What we do is every month we get reports from the Ohio Department of Health, and based on those reports, we cancel, they notify us who passed away and we cancel their registration. So Ruth P passed away on 4/10/2012. She was canceling our voter registration database at that time. There had been no voter activity on her record since 2012. The CCBOE received a registration card in Ruth's name that contained matching printed name, a matching address, and a matching date of birth. I reached out and I was able to find the household, and I contacted Ruth's former household and was able to speak with her niece, Amber, and she confirmed that Ruth had in fact passed away 12 years ago, and that no one else by that same name also lives at that household. So there is no other Ruth P by that same name. Black Fork, so we did reach out to Black Fork Strategies. They identified the registration card. Now, one thing I do want to kind of point out at the bottom here of the second card, this is the card that was submitted by Black Fork Strategies. They have a code number on the bottom there that they use for their own record keeping and tracking down in the bottom right-hand corner. We had been asking, we asked all our voter registration drive-throughs to have their circulators put, so for us to be able to identify circulators, like if we start seeing something, for them to put their initials and an identifying 4-digit number. So this way, if we see HC 1234, we could see a pattern there and maybe be able to pick up on things earlier. Also, it helps us with being able to identify circulators that are of concern. They weren't initially cooperative with that, but after, I would say after the 4th of July, probably for about the last month and a half or so, they have been including at least the initials of their circulators, which I think helped to identify who the circulator was in this case.
The question I have, since we know and they know that we know who these canvassers and circulators are, have these two people for Black Fork and the other person, the one person for the other group, Second Street, who are clearly circulating registration cards for deceased people, have they been fired?
I don't know specifically about these individuals. I do know that there has been people when we've notified them regarding issues.
This is egregious.
Yeah, I can't speak specifically for these circulators at this point, what their status is.
Is that the policy of these agencies?
They have been cooperative, I would say, when other things were pointed out, or they have notified us that they've let certain people go based on what they viewed as bad behavior.
Well,
Yeah,
they
obviously,
know
illegal
we
behavior.
think this constitutes,
Yes, we met with them. We did, have a Zoom call with them last Friday. We didn't want to play gotcha, so we gave them a heads up that this was coming down the pipe. We didn't specifically, in this case, identify these,
I don't think that they haven't had an opportunity yet to probably terminate these individuals because this. We did have that call with them yet last week, but there will be follow-up calls with them.
Second case is, Melbourne J. He passed away in, March 1st, 2021. And you can see again, a copy of the ODH file above that. He was canceled in our voter registration database. We've had no voter activity since 2020. We received a registration card in his name with a matching printed name, matching date of birth, matching last 4 digits of his social security number. We attempted to contact his former residence, but to no avail. This card also was circulated by Blackboard Strategies, a circulator of theirs. The third example is Doris G. She passed away in 1995. She was canceling our voter registration system at that time. She's had no voter activity since 1995. And the CCBOE received a registration card in her name with the matching printed name, address, date of birth, and last 4 digits of the social security number as well.
and that's not Blackboard.
No, this one is Second Street Associates, and they actually do, if you look on the bottom of that card, they do put initials and an identifying 4-digit number, which for us was something that we asked for, and I think it is a good quality assurance measure for these organizations to adhere by. It's not, they're not by law required to do that, but I think it would be, we've recommended that as a best practices for other counties across the state. So we could either pause at this point, or I could just bring up the last scenario and then go from there.
Any questions for Mr. Gallagher based on what you just presented?
Thanks for clear.
Okay. Mr.
Okay.
Gallagher?
If I could just, Chairman, thank you. And to something that board member Stickett was kind of speaking to. So like these 3 deceased individuals and these other ones, all different circulators.
Right.
You know, so it's, so what we did find, at least through this little part, is one bad apple. There's
There's sort of a pattern, yeah.
just as a point of information.
It seems somebody would have to have access to all this particular information. People have been dead for 12 years. That concerns where are they getting, where they get their social security number, they get the date of birth, they get the original address. They have all that particular information. It's like there's something going on. But what do they get paid per registration?
We've had conversations with it. They've said they do not pay per card. What they do is pay per day of work. There are like minimum requirements
That's what
that
I'm
they have
wondering.
to provide.
There's so many you have to get in a day.
It's not like if you have a bad day, you get fired or something like that, but I think it's somewhat of an average type of production that is.
There's no incentive for
expected.
getting more names.
No.
Well, it sounds like they.
Well, you know what, I don't wanna
Yeah.
express everything for them, but what they have communicated to us was it was more of this, just a simple, like, that they get paid per hour, per day, and it's based with certain expectations, but not a quota per se.
How do they get paid?
Do we see duplicates, cards from each organization, so did I pick that up?
Well, actually, go ahead, that's our third
Okay.
scenario, so thank you for that lead in.
So what are they, they're canvassers from each organization standing at the same place and saying, okay, you sign them up, sign mine, let me sign them up too? I mean, how are we getting, the same registration cards from two different organizations.
That's a good question.
Different-
Yeah. What we know, and I will speak for us, what our voter registration staff, which do a great job, and by the way, they have been
They catch these,
processing
yeah.
a lot of registration cards. They go through a lot of due diligence, and I want to give them a shout out because they do work hard. And it is because of their efforts that a lot of these things are identified and brought to the board for action. So as they were entering voter registration cards, they noticed a lot of duplicates of the same person being registered over and over.
Okay.
So what we were able to do is through, with the IT department in Mary Hannah, they were able to go back and derive a report from March 1st through August 14th to look to see how many duplicate registration cards do we receive. So, and we didn't, we figured, okay, 2 cards, someone might have registered or updated their address and again, updated again. But within that 4.5 months, we received 17,000 voter registration cards for 6,500 voters. So, a 2 to 1 or 3 to 1. Drilling that down a little bit deeper, again, not taking people of 2 or more, but just 3 duplicate cards for a voter. We had over 1,300 cases where those individuals in those 4 months provided 3 duplicate registration cards. As you can see in your booklet, it kind of breaks it all the way down to 14, 15, 16, 19 voter registration cards, duplicate cards for the same individual,
Do you think there's some overlap with employment with these 2 agencies? I mean, to have such, you know what I mean? That's maybe someone's working at both.
Yeah, predominantly it would seem like it would with individuals, it would be mostly with one circuit, but we did see that with that, they might have like 18 from one and 1 from another organization, or 4 and 12 from another.
Or family members, maybe,
Yeah.
or
Now-
related folks maybe that are.
Now, the good thing is these individuals were identified as duplicate voter registrations. So it's not like that individual could have gone and was registered 19 times and would have been able to vote 19 times. But it does create,
Different addresses.
sometimes it was little tweaks, or it was jumping back and forth between addresses. Sometimes it was a small tweak in the address and so forth. So it can either, it creates a burden for the staff, but apart from that, I mean, they do their job. We don't want to see people's voter registrations become corrupted, and we
Right.
also don't want the possibility of, if there's a duplicate that they don't catch, that something could go forward. So although there are multiple circulators involved here, it is all going through the organizations, and especially if they're able to have their serial numbers and able to track individuals. I don't know to what depth. We believe that they have some vision towards duplicates, but it seems like some additional effort should be taken somewhere to help prevent this rather than just dealing with it on the back
Can
end.
we talk to these organizations about their Q&A efforts? Are they going through before we get the cards? Are
They
they?
do have, they've
Are they
expressed that they
vetting them?
have QA operations that they do. We've identified these issues with them. We're not involved in their organization to know what the results have been.
A lot of.
Yeah.
Well, when you have the follow-up call, you're saying you're having a follow-up conversation with them or
Well,
no?
we want to, as far as bring to the attention, the names of the individuals who circulated the cards associated with deceased voters. I want to make them
We can
aware.
find out what their Q&A procedures are. That would just be helpful. I think we had them come in at one time. I don't know if it was these 2 agencies, but other registration organizations had come in at one time, and they said they shared with us some of the Q&A process they had. This was a while back then.
I have a question though. We did make the referral a couple of times on Blackboard to that Secretary of State investigation unit. Are we updating as we are coming into these issues since we have that referral? And I know there's an investigation unit that is looking at this. I mean, are we updating this new information of these most recent cases, situations, or identified circulators to them as well? Or is that something we have to do each meeting, refer and keep sending information over? I mean, since we already made the referral.
Where we haven't provided any more information to them. This would be probably the time that's ripe to
Okay.
send something down, and I don't think where we had previously referred activity from Black Fork.
We haven't done the other.
And we have not done second.
I mean, I think that would be appropriate only because this is, you guys have done a great job identifying this issue. And I applaud the department and all the work here, but I mean, since we've already made these referrals, it would make sense to, I mean, continue to send that. And I would probably also think it'd be right, according to what you're saying, that we have them look at the Second Street Associates as well.
I would, think that with Second Street, it's time for them also.
It's probably appropriate for the board to vote and to send it rather than.
So we should make a motion to include Second Street, but then, and then say maybe an update with additional information on previous referrals. Would that be appropriate? Or do we
So
have,
something to the effect that, director, deputy director on an ongoing basis as registration anomalies arise, present that to the.
oh, okay, I like that, then we don't have to keep voting,
We already
that's
have to
very
do
smart,
that.
yeah, cause you should, cause we already made the referral, so.
Thank you. Mr. Gallagher, anything else?
No, those were the scenarios we wanted to cover
Mr.
today.
Weed, anything that you need to add to this?
No, I think, deputy director covered everything.
Thank you,
Good
Mr.
job.
Pilati, anything else from your end?
No, I just think, I think would be appreciated if, there would, you know, to try to get it clear that we just on an ongoing basis.
Yeah.
in Real time, as close to real time as possible.
Could that be with one motion with both, or referral Second Street and?
One second, just because we have the discussion, I do know that you did reach out to, these organizations and said, we're not playing gotcha, that they might be here. Is anybody here from Black Fork or, Second
Second
Street?
Street.
I would allow you to make a public comment. It won't be back and forth, but you may make public comment to the board if you're here from one of those organizations. Okay, neither are here, so Ms. Dickon, it seems like you're ready for it.
I can go ahead and make that motion, just to be clear, for a referral, on, Second Street Associates. And combine with, allowing our staff and directors to provide additional information on previous referrals on an ongoing basis. And that previous referral be Black Fork Strategies, and anything additional is Second Street Associates. That's,
Are we, with respect to the 3 deceased
I
cards
think I
or
would
just in
include
general?
everything.
Oh, okay.
I mean, I would assume all of this that you presented to us to be submitted under the previous referral. And then as like, in other words, in every meeting, they don't have to say, here's more information, they can just go ahead and send it. Is that, does that sound correct to you?
Yes, so I
Okay.
would do what my understanding would be, for example, as an example, we would send down, all this information.
Right,
And
and
then
the deceased people
they
particularly.
would have that as well as if we have similar type challenges, say in
And
the
the
future.
situation with Mr. Thomas and,
Yes.
okay, all of that, yeah.
I'll second that motion.
Okay, properly moved in second, all in favor, aye?
Aye.
The ayes have it. Thank you, and thank you, Mr. Weed, thank you for what your staff.
And, one other question.
Same
Oh,
dates.
But one other question, though, we made these referrals, I know it's an ongoing investigation, and to your point, it seems like there's a lot going on around the state. Are we able to get any updates on that, or maybe when it's more ripe, or?
We did, after the last board
Oh,
meeting, we
okay.
did make a request to the Secretary of State's office, and we just got a notice that both the Black Fork Strategies investigation as well as 1735 Elsinore referrals are still active in their investigation.
I know ongoing investigations, you know, yeah, I wouldn't expect any public comment on those if they're still going, but that's good to know.
And I would just add to that, those updates are coming from the Attorney General's office.
Oh, okay,
So
thank you for that,
that's where
all right.
I think the investigation now lies.
Oh, okay, that's good point, thank you for that clarification.
Thank you. We will move to the personnel agenda that's before us. And I move the following, the promotion of Mary Johnny, from Administrative Assistant Clerk to the Board to Assistant Manager Registration Department effective August 20th, and the appointment of Sam Littlejohn to Election Official 1 Ballot Prep and Tab Department effective August 26th. Demetria Brown, to Election Official 1 Ballot Prep and Tab Department effective August 26th. Michelle Burgos to election official one, registration department, effective August 26th. Move those and we'll take the others as a separate motion.
I'll second that.
Second by Ms. Chappelle, all in favor, aye?
Aye.
Aye, the ayes have it. And I move the following, in order to effectively administer the November 5th, 2024 election, Cuyahoga County Board of Elections will observe Columbus Day, Monday, October 14th, 2024, and Veterans Day, Monday, November 11th, 2024, on alternate dates. And the Board of Elections will be open to the public on October 14th and November 11th. Columbus Day and 2024 Veterans Day 2024 will be observed on Thursday, December 26th and Friday, December 27th, 2024. And the board will be closed to the public on December 26th and December 27th, 2024.
Second?
Second by Ms. Chappelle, all in favor?
Aye.
Aye. Board gets my birthday off again.
Wondering we do.
Sorry. All right, and I move that effective today, August 19th, 2024, the election officials department will be returned to the previous name of poll worker department.
A second.
Second by Ms. Chappelle, all in favor?
Aye.
All right. We call them poll workers anyway.
Yeah.
All right, Mr. Perlotti.
Okay, so I do have, just want to give some information relative to, the upcoming November 5th election. For myself, I made, 8 points at least I wanted to hit on. And then we'll take questions. First, applications are still coming in for vote by mail. As far as a non-UCAVA, we're at 24,915 already. And UCAVA, we have 1,530 UCAVA applications that have come in. So we will have to process those. Again, Secretary of State will be sending things out statewide. It'll be around Labor Day. And so all of a sudden we'll see that number skyrocket. Next, wanted to hit on PEO recruitment that actually in the poll worker department that has started. We have reached out to our voting location managers and deputies first. We have 263 individuals who have signed up already for classes that will start following September 6th. Tomorrow, this Tuesday, we'll send another email out to that group of the voting location managers and deputies who haven't signed up who previously served, to get that closer to the 300 poll location, to each number that we need to get to. This Wednesday will be the first time that we sent out a mass email to returning poll workers from the March primary election to get them to sign up for poll worker training. So we have temporary employees in the department and we're going at full tilt on recruitment. As far as early in person, we have released and received our bids back for tents for the parking lot. So we have those and we awarded those. We have filed permits with the city of Cleveland for basically call it an obstruction permit to put those on the sidewalk. So we have everything moving along for that. You may have noticed when you came in, the ballot box move is underway. The Public Works has poured a new pad closer to the exit. And over this past weekend, they moved the signage and the safety bollards for that box. And then this week, the box itself will make its way from where it currently is to the new location. And the county electricians have come in and they've already repositioned the streaming camera to the new location. So that will be up and functional. Next week, we will be importing the ballot in there, and so we can start to do ballot layout. And once we do that, then we start the whole proofing process. So that will be underway. This afternoon, with community outreach, iHeartRadio, which has a series of radio stations in the area, they are going to, provide us with some free PSAs. So I'm gonna go down and record, a few of those, and then I'll push those out. I think they said over 11 channels that are in their portfolio. So, that's a first for us, which is nice, and
Good.
that's something that they're doing at no charge, that they want to help get the word out for people that are develop and participate.
Perfect.
Last week on Thursday, we had a webinar with some individuals from the federal government, and then on Friday, we had a tabletop exercise that was conducted by the county's emergency management department down at the Harbor Garage. It was a real good exercise, dealing with some things with compromised mail, and they really brought in a big team. There was Cleveland Fire, Suburban Fire, Hazmat, Cleveland Police, FBI, Homeland Security. Jonathan, who we spoke with on Thursday, was there. For elections, we had folks there, Sheriff's Department, so it was a robust post office. It was all there, and we went through it. It was 3 to 4 hour exercise that was informative, good, very worth our time. Like the Thursday call led to a couple action items for us, so did Friday. Some good insights that we'll be working on to prepare for the upcoming November election. So that was a real positive experience. And then the last thing I wanted to hit on, and then take whatever questions you may have, is Tony and I are in the process. We are working on, and if we can get clearance, we'll be making a recommendation, should be making a recommendation at our September board meeting. We want to, for the month of early voting, we want to collect absentee ballots in the turn lane on East 30th for all hours that were open for early in-person voting. So we want to basically build a safety square with, like when you drive and see construction on freeway, those things in the turn lane, where we would have tents and would be able to collect from cars traveling both north and south on the street, try to alleviate some of the congestion that we have. The ballot box would be open in a parking lot, but we would have that where we would staff that up. Again, all hours that were open for early in-person voting to help with congestion, safety, ease the process. We have reached out to the Secretary of State's office to make them aware of our desire to do that and see if it is acceptable, meets criteria of directives, and promotes safeties of voters. So we're waiting, we've asked for a meeting, we're waiting to have that to make sure that they are okay with that. We've also reached out to Cleveland Police and the Traffic Commissioner to get their buy-in, because that would be probably something where we would need permits, and if there's any safety standard we would need to do in that regard. So we want to get as much of this ironed out as possible in advance. Don't want to repeat of 2020, where we went through effort to have some satellite pickups to all of a sudden have it shut down. We want to flush everything out in advance and be able then to come and see if this board would approve for us, because you have to publish schedules to do that at a future meeting. So we're trying to get all that groundwork out of the way. But as we know, we don't have a huge parking lot, not a lot of space, and a lot of people like to utilize that drop box. They get the ballot mail to their home, and then they want to bring it down there and personally hand it in. And we want to be able to provide for an easier, more fluid way for them to do that. So that's again, something that we want to do. Tony and I walked the street, found a spot where it doesn't impact anyone's aprons in or out of their parking lot for our neighbors. It's only about 125 feet away from the property line, so it's right there. And one thing too, if we were able to go forward with this, we would have a law enforcement officer that would be in that box of collection at all times, making sure that the ballots are secured and everything's okay in that regard. So that's a big thing that we want, that we need to pull off, and hopefully everyone else that agrees with that falls in line. So
Just had a quick question. Just remind me, wasn't there a one-way change, or when we had that during the last election where you could only access 30th from one angle, like you had to go around to come up through Chester, would that, remind me if that, or if I'm making that up, or if I do recollect that, and then how would that impact? You said we had traffic going each way,
Sure.
would that still be, put into place that you can only come south?
I think there was a what, certain.
So what happened in 2020 is, so we did, we had traffic going both ways the whole time.
Correct.
However, once you came into our parking lot, you could only make a right out of the parking lot and continue southbound, you couldn't make a left. And when traveling north, you could not make a left. into the
Okay,
parking
that's
lot.
what I'm thinking.
Couldn't make a left.
So really, it was just straight.
Okay.
That was it. So we will have Campus International parking. We signed a contract with the former Bryan Stratton. So we're gonna have that going on. So it would be a similar type thing in that you're going north, you go that way. And if you're coming south, we want you to know that lot too. Because what we'll do is our lot would be designated for curbside and ADA. And I'm just gonna call about half of the lot will be tented to have a line undercover within 100 feet of the door and try to keep as many people from standing on the sidewalk down the street that's safer, closer, up this way. So, and then
And what
what's,
about the line that is likely to be wrapped down 30th and down Carnegie and Chester and remember those lines that
Right.
all the way down to the highway?
oh yes, so the
Had
tent,
those,
the tent, what can go underneath that tent is about equivalent of the property line down to the corner at Chester.
oh,
Ring, it's, I forget, it's something 250 to 300 linear feet.
that's a big, yeah, I've never seen it that, but that's great, that's
Yeah.
a big help.
That's the goal.
Yeah.
Doesn't mean that it may still not get off the sidewalk, but hopefully it doesn't get much further than maybe like the apartment that's right next door. And so we can physically always see the end of the line, which then is helpful to monitor the line and make sure that everyone is 10 feet away from the line and not engaging in activities that they shouldn't be.
Sure.
So those are just a few of the points. Any other questions? It's go time. We're here.
Yeah.
Gallagher, anything?
No.
All right, thank you so much. The chair has not received any request for public comment. Nor do I have a request for executive session, so I move to adjourn the meeting.
Second.
All in favor, aye?
Aye.
Ayes have it. Have a great day. Thank you, everybody.
You the second, just 1 minute, the new fiscal name for Tara. Today's their first day.
I felt that.